Ciao a tutti. This is Prof Jo at Prof Jo Explains, and this is the recap show of day 4 of the Brian Walshe trial, murder trial. I don't know how many of you watched the trial today or had a chance to see any of it. I'm sure a lot of you had other things to do when we're working. So I will, try to in some way catch everybody up, but then address some things that I thought were really either interesting or really important today. Today, there were more witnesses, law enforcement witnesses that were dealing with the forensic kinds of things, the data from the cell phones, and the data were used both to show where the cell phone was, or at least the general area where the cell phone was, as well as Safari searches that were made on a cell phone. And there were 2 cell phones in particular that they were looking at. One was an iPhone SE, the other was an iPhone 13 mini. Both of those were phones that Brian Walshe used. He also used a couple of other phones, and I think one of them was his mother's that they talked about. But the 2 that were most significant were the cell phone that ended in 8082, the phone number, which was the iPhone SE, and the one that ended in 8646, which was the mini. And a lot of people in the chat today were having difficulty following whose phone was being used and to whom the phone call was being made. And I suggested that you need a glossary of these things. Someone in the chat, and I apologize, I don't remember who it was, said, well, every time they say phone number 8646, they should say Brian Walshe's iPhone mini, so you can keep track. And that this judge is doing a great job of identifying things so that the record is clear and so it's clear to the jury. But that level of getting detail and following it, I've never seen a judge do, and I don't think you'll ever expect it. But now you're forewarned. When you hear an expert talk about things and start using phone numbers, you just take out a little notepad and write down each one and write down whose it is, so you have your own little glossary that you can follow. But I do admit, I mean, there were a lot of times, and every once in a while the prosecutor did then say, and whose was that? But he certainly didn't do it all the time. Another thing that came up was, and it came up in different ways today. Why is it? Well, you know what? I'll hold off until we get there rather than jump ahead that way. So what we did see today, or at least discussion today, was not only the cell phone, the Celebrate records that can give you some information about where the phone is located and information about to whom the phone is called or from whom the phone is receiving a call. But we also learned that there's something called license plate readers that the law enforcement can use. And of course, there are cameras all over the place. So there were, let me start then. I mean, that just gives you an idea of the sort of the general background today. And what they were trying to do is they're starting to connect up various things. So for example, the photo that I think most of you have seen of someone who looks an incredible, very, very, very much like Brian Walshe in that Home Depot with that cart with $450 worth of cleaning supplies. And he's got gloves on and he's got a mask on, because I think that he thinks that way nobody's going to notice him. That alone, the jury could say, yeah, that looks like him. We're sold. But better to have corroborating evidence about it. So one set of corroborating evidence that they have is the searches that he did on Google and Yahoo the days after the morning of, or the late night of New Year's Eve going into the early hours of New Year's Day, where he's asking I'm going to generalize now. What cleaning supplies do I need? What's the best way to get rid of a smell? How do you get blood out of things? He's asking those questions. So now you can connect that to what he purchased at Home Depot, and they corroborate each other. And it gives more reason to believe the person who's pushing that cart is Brian Walshe. Well, today we now have the the cell records of where his car was on certain days. Now they've got the photo, which would be time stamped as to the individual pushing that cart. When did that happen? And now they'll be able to cross-reference with the phones, and I'm sure they're going to find this. They haven't, I don't think they've really done it yet, but connect up the phone that was near that Home Depot at the time that someone was in that Home Depot buying the supplies. And now you've got real corroboration that the person pushing that cart was Brian Walshe. You don't have to depend on the fact that it looked like Brian Walshe. You've sort of nailed, gotten the whole enchilada and really captured that this is Brian Walshe. So that's right. They're all good. There's the picture. I mean, it's hard to say it's he, but I mean, I don't know, you can't see my finger, but if you look at his face, that looks a lot like the person we've seen in court. But that by itself, a juror could say it looks a lot like him, but I need to be persuaded of his guilt beyond a reasonable doubt, and this is not getting me there. But when you add the phone records that are going to show that he was in the area of that Home Depot at the time, and you add the Google searches where he's asking about those sorts of supplies that are now sitting in his cart, it would be hard to say that anyone wouldn't be convinced that that's Brian Walshe in the store. So that's a good example of how you corroborate evidence. It's also a really good example of what I've said before. No one witness can get you all the information on a particular subject. In the case of Brian Walshe in the store, you've got three different things. You've got the photo, which is going to be introduced into evidence maybe by one law enforcement expert, the cellulite, the cell phone records, another forensic expert, and maybe a third who was the one who was assigned to go through the Google searches. So you're going to have three things going together. One witness is not going to be able to testify to all three, and so you're kind of left hanging. There was a better example of that, and that's the hole in the ceiling. And I'm calling it the curious affair of the hole in the ceiling. And those of you who know Sherlock Holmes will get that reference. The first day, there were pictures of the house. And you probably, if you were with me that day, I complained that I didn't see any reason why you needed pictures of the attic and the basement and the kitchen table and the credenza or whatever it was and the dining room table. It seemed to me there were lots of pictures, a bathroom on the first floor, and it didn't seem to me you needed all those pictures. I've always said that you have to wait and see what the entire case is, but then I also don't listen to my own advice and get ahead of it. And I was just curious and a little impatient about it. But I think what we're going to now see is those pictures are going to tie up to where that hole in the ceiling was and what was above the hole in the ceiling. Because the question, if you saw that picture of the hole in the ceiling from today's trial when it was on the screen, and there were two pictures, it was a pretty big hole. Now, I don't do things around the house. In fact, this wall behind me, when I knew that I was going to try to have a YouTube channel, I thought I should paint the wall. You can't see what a mess that wall is. If I took a camera close, you'd see how ill I did this wall. It's the first time I've painted a wall in my life. I had paint where it shouldn't have been, even though I had tape all over the place. But so that's a digression to tell you that when I was trying to imagine how that hole could have been created in the ceiling, I went to, could you throw something heavy against the ceiling and would it make a hole in the wall? And I thought to myself, that can't be. Then I thought, well, maybe you could get a very, a steel or an iron, whatever, and pound a hole in the wall. Maybe that would work, but there's no reasonable explanation why anybody would do it. Joel Waldman looked at the hole in the wall and said it's probably water damage or something from the room above, which of course is the reasonable explanation here. It was not one that I found on my own. And that's why I think what we may see now is, now that we see the hole in the wall, that there is going to be now testimony or evidence or something to suggest that what was happening above may be his washing the utensils that he used, or Uh, who knows? I can't imagine that he actually dismembered her up there. If there's a bathtub up there, I don't remember now what room was where. Can't imagine it because the boys would be sleeping up there. He's got 3 little boys. But in any event, there's now some tie-in. So what we heard today, we saw more pictures of well, we didn't see more. We saw the same 2 pictures that a new law enforcement officer also identified. And then we had a painter who testified that Brian Walshe, on the day after New Year's, or within a day or 2, had talked about getting the hole repaired and painting done on that. So we're now starting to see that the Commonwealth sees their significance in that hole, and I am fairly confident that we're going to hear more about that hole in the wall with this Commonwealth giving its theory of what happened and why that hole ended up there. So we also got more information about what Brian Walshe may have known or did know about Anna's affair with Bill Fausto. Remember, the defense opened saying he didn't know a thing about him, and there's Bill Fausto on the stand. But we're getting information that that's not true. There were text messages, and we had a day of argument on and off about these text messages that went from Bill Fausto to Anna and from Anna to Bill Fausto. The defense will be able to introduce a couple of them that suggests that there really wasn't a problem with the marriage. And actually, Fausto testified today that Anna loved Brian Walshe, did not want to hurt Brian Walshe, did not want him to know about the affair if he was going to know from anyone but her, which helps the defense on their theory that marriage was just going fine. But there's also information from Fausto that I think is in a couple of those text messages, and he testified a little about it, that she was stressed, she was unhappy. She was very unhappy about the fact and increasingly despondent that the boys were in Massachusetts and she couldn't have them in DC with her. And what had happened was that Brian Walshe, was waiting to be sentenced, and over part of the time had not even been, I don't even think the conviction had happened, but waiting to be sentenced on that fraud that he had committed, trying to sell Andy Warhol counterfeits as real Andy Warhols. Because of that, he was on home arrest. And I have not had a chance to go back and verify this, but it sounds as though one of the reasons why he was permitted to be on home arrest rather than to be incarcerated waiting for the sentence, because he'd been convicted, and at that point, usually you're not allowed to walk around. If there's going to be an incarcerative sentence, you go to jail immediately. But it sounds as though one of the reasons that he was permitted to be on home arrest was that he was the primary caregiver for the 3 boys. She had gotten that great job in DC. They needed the money because Brian Walshe wouldn't have a job. This job was paying her twice what she was making. And at one point, there's something in one of the things Brian Walshe said that sounded as though it was 3 times the amount of money. So their agreement was she was going to go to DC, take that job with the expectation that the rest of the family would join her. She found a townhouse in the District of Columbia that would be big enough for a bedroom for the master bedroom, and then 3 bedrooms, 1 for each of the boys. But the sentencing kept being delayed, and it was going on, and she was becoming increasingly despondent and upset that she couldn't have the boys. Fausto also testified that Anna had seen one of her credit card bills, and of course she was paying all the bills, and had seen credit card expenditures or purchases by her sit-at-home, not working spouse in Massachusetts. And it wasn't bread for the table, it was sports memorabilia. And she was very annoyed about that. And there was an altercation about that also. So there was stress in this marriage, and it was increasing because of the time in which she was several hundred miles away from her children. She wanted the children with her. So that was Faustow's testimony. We did not see the texts. I believe we will at some point. If not, I think the prosecutor will certainly refer to them in closing. So that was his testimony. As I say, we then went into the law enforcement officer testimonies, and there was more information, more text, and of course we start now seeing how the searches of the trash, the throwing the trash in the trash bins is going to connect. They had a wonderful witness, I thought, who manages one of them, and boy, I'd hire her in a heartbeat to do anything I needed somebody to manage, because she was on top of how that apartment complex worked like nobody's business. She was just great. And she testified because Brian Walshe evidently distributed at least a couple of those trash bags in the trash bins at this apartment complex that she was managing. Now you see the car. I don't think there was an opportunity to see the license plate. You saw the person bringing the trash bags, but there was no way that I could identify that person as Brian Walshe. But there are phone records as to where that car of Brian Walshe's, or at least the phone of Brian Walshe's, was at the time that we can see on the cameras that car was in that apartment complex, throwing garbage out, throwing trash cans out. So again, they're going to be able to connect the two things and make a very strong case that it was Brian Walshe who was there throwing out the trash, although from the picture of the car and the person in the film, you couldn't do that, certainly couldn't do it conclusively. Not that you needed to be conclusive, and there's a picture of it. You couldn't identify that as Brian Walshe. I don't know that you could even identify that person as a male, but you start connecting things and it becomes a pretty strong case. And let me depart for just a minute here. No piece of evidence has to be proved beyond a reasonable doubt. So it isn't though every piece of evidence the jury has to say, gee, beyond a reasonable doubt, I believe this to mean. It's the whole grouping of all the evidence. So it's all little pieces, and it's the entire wall that has to prove beyond a reasonable doubt guilt. But every little piece, little brick that you put in the wall doesn't independently have to meet that standard. It's just all of it together. But the more you can make each little piece significant in terms of how clear it's showing guilt, the stronger, the sturdier, the bigger the wall becomes. So it's important to try to do it, and that's what they were doing. There was more evidence that Brian Walshe knew about the affair that came in today. There were new, at least new to me, phone records from which Brian Walshe, or somebody using Brian Walshe's phone, so I'll say it carefully, was doing safari searches on Christmas Day. And some of them were questions about William Fastow. So that's another remember, there's going to be other things showing that he knew who William Fastow was, and he knew there was an affair. This was another little piece that goes to that showing. But the really important thing to me was, among those safari searches that he did were two. One was he searched a DC plane crash. Remember, Anna Walshe was supposed to fly up to Boston early in the morning on Christmas Day. She spent Christmas Eve with William Fastow. She was supposed to fly up that next morning. There was a snowstorm. Her flight was canceled. She couldn't get a flight out. She ended up driving, and I don't know how many hours would be from DC to Boston, but it's got to be DC to where I am is about 3.5 hours. Boston's another 2.5, 3 from me. So it's got to be 6, 7 hour drive. And if it's bad weather, maybe even longer. So she had to drive up. She missed Christmas morning with the kids opening the gifts and seeing that Santa came, which must have been difficult for her. On the other hand, she's a victim and I have all the sympathy in the world for her. And she was in maybe a really bad marriage and et cetera, et cetera, et cetera. But to choose to be in Washington with your lover on Christmas Eve rather than fly up on Christmas Eve to be with your children is not a choice that I would make or not a choice that I would endorse by any means. But in any event, she drives up to get to the kids. During the day, on Christmas Day, Brian Walshe does 2 safari churches, 3 general safari searches. One was questions, but where the search term, they called it, what did they call it? It wasn't source, it was, should have written this down. But anyway, it was the title of the search was William Fastow. So, you have to draw inferences, but it's Christmas Day. His wife isn't there. And whose name is he putting in that search engine on Safari? It's William Fastow. Again, it's a little piece towards saying, sure, he knew that they were having an affair. But he also put in 2 other searches. One was a search of a DC plane crash. Now, arguably, you could say she wasn't arriving and he was worried that she got on a plane and the plane crashed and he was just checking to see if there'd been a plane crash. I doubt, and I don't know this for sure, but I doubt that she didn't text him or phone or email or do something to let him know that she was delayed and was going to be late. It just doesn't strike me as something that she would have done, particularly knowing that the kids were waiting for her. So I think he had to have known that she was delayed, but I assume he can argue that that safari search was really just to find out if that's why she hadn't arrived. But the other one was Anna Walshe found dead. And this is on December 25. It's a week before she's actually found dead, according to him. And if we're looking for premeditation and deliberation or intent before the crime, this is, I think, a fairly significant piece in making that argument, making that case. Because what we will have now is evidence, pretty good evidence, from which the jury can conclude he knew that there was an affair, evidence that he was stressed for money. His mother was paying the rent on the apartment. Anna Walshe was paying the other bills. And so he would be stressed for money. He probably, his ego, he strikes me as somebody who likes to, thinks he's in control, thinks he's really a capable person. And the fact that she was having an affair would probably strike him at his ego pretty significantly. So they'll have all that as to what occurred or what he knew prior to. And with regard to, did he know there was having an affair? We know his mother paid for a private investigator to look into it. He says he didn't know about it. It is hard for me to believe that she was paying somebody to investigate and he didn't know in the first place. Why would she be even investigating if he hadn't suggested to her that Anna might be having an affair? I mean, what would lead her to even get to that place? So there's a lot from which now we're getting more on the front end to give the jury a hook, because on the back end, there's an incredible amount of evidence that can be used. So I think the Anna Walshe found dead is pretty significant in terms of the evidence that came out today. Oh, finally, there was a discussion again and a resolution from the judge about whether the information that Brian Walshe had pled to those 2 other charges, the moving the body or getting rid of the body illegally and the lying to police. Brian Walshe has been pushing that he wants the evidence of those pleas before the jury. He says this shows that he was taking responsibility. Now, as an aside, if he's taking responsibility, it would be nice if he said what he did with her body. But let's come back here to the direct route. He says it's to show responsibility. The Commonwealth has been concerned that the jury in this case, if they know he has pled guilty to 2 charges and is going to be sentenced to 2 charges, might be more willing to say, this is a tough case. We don't know if there's enough evidence. We can acquit because he's going to spend significant time in prison anyway. So the prosecution has been pushing not to let the evidence of those pleas get before the jury. The judge said today that she had researched this some, and that's how she feels also, because the maximum sentence for moving or disposing of a body illegally is 10 years. But if you're moving or disposing a body is associated with a crime for which you can get a life sentence, and that would be murder 1, then the maximum sentence for the moving, disposing of the body goes up to 20 years. And the judge said she did not want to sentence on that charge in advance of the jury decision on the murder 1 charge in this case. What she sounded as though she were saying was she thinks she could, but she also thinks it would be would be an appealable issue that she doesn't want in the case to sentence ahead of time. Now, from that, one can infer that what she's inclined to do on that moving or a body illegally is a sentence of higher than 10 years, because otherwise it wouldn't matter. Sentence to 10, and you're done. But for her to be concerned about it suggests to me that she is going to go to more than 10 years on that charge. And she said she would prefer to wait and see what the jury does, and then sentence on the murder 1 if he's convicted, and sentence on the other 2 charges at that time. I can't believe this will happen, but if he were acquitted, the issue would be, did he move or move the body illegally associated with a crime that could get a life sentence, even if he was never convicted for that crime? That's the legal issue that she doesn't want to be dealing with. The jury also theoretically could hang on the murder 1, the crime with life. And then again, but more realistically here, the Commonwealth could say it's associated with the crime. They didn't acquit. They just said they were hung on that. And what the judge said today was, well, in that case, she would hear argument on the sentence. It would be the prosecutor's burden. It wouldn't be beyond a reasonable doubt, but it would be the prosecutor's burden to show that the moving of the body was associated with the crime of murder 1, even if the jury hung on murder 1. I hope that was clear. If it wasn't, send me a question. You can get me on askprofjo@gmail.com, or I suppose you could put it in the chat here and I'll try it again. But you may want to just sort of cogitate about it a little and see if you can follow it before I do it again. Now, there were questions today that I didn't have a chance to respond to with regard to the guilty plea, and they related to, I think, was there, something about a plea bargain. There was no plea bargain. You can plead to a charge and just say, I'm doing it. And that's what the defense wants to get to the jury. He didn't get anything out of this. It was just, he just man up. Is that what they say? Man up or manned up? I don't even know how you put it together, but didn't get any deal whatsoever out of it. And you can do that. You can plead. You don't have to get any return, reduction of sentence or anything else from the prosecution. And the prosecution wasn't about to give him anything. They didn't want him to plead ahead. In fact, at a pretrial hearing before this trial, they argued that the judge had the authority not to take the plea and force him to go to trial on the charges. And she ultimately said she didn't think she had that authority, so she took the pleas. So a plea bargain is what happens a lot, but it's, I say, I'm charged with murder 1. I'll plead. You won't have to do the trial, no expense of the trial. I'll tell you what happened if you'll give me murder too. Or I'll plead to murder too if you agree that, the maximum is 30 years, that you're going to recommend to the judge that I serve no more than 20 years. That happens a lot. But you don't have to get any deal like that. You can just plead. It doesn't happen very often, but you can just plead and say, I know I'm not getting out of it, but I'm going to plead. Maybe because you want to take responsibility. That's not Brian's Walsh's situation. He waited, quite a while, and he still hasn't said what he did with her body, which he will have to say if he gets on the stand. So I hope that explains that piece of what I'm. It seemed to be that there was a question about this morning or this afternoon in the chat. So that, I think, for me, covers. Oh, let me say one other thing. I forgot about this part of it because I really thought this was interesting. And this relates to, was she going to stay in the marriage, which is what Brian Walshe contends. He didn't know that there was any kind of an affair. They were getting along, and the plan was that he and the kids would be moving to D.C. But what you get from William Fausto is, yes, she loved him. Yes, she didn't want to hurt him. But he also said that they had agreed that when she got back from New Year's in Massachusetts, they were supposed to celebrate New Year's on January 4, that they were going to sit down and talk about a 1, 3, and 5-year plan. Now, that does seem to me like a little dispassionate business arrangement about talking about your life with somebody that you're in love with, or say you're in love with, but that's how he described it. Now, that 1, 3, 5-year plan certainly at least suggests that her commitment to the marriage with Brian Fausto was not hard and fast. She was thinking about at least leaving him, and maybe thinking seriously about leaving him, and maybe being ready to leave him. And, two things can be going on at the same time. You can love someone and feel sorry for someone and not want to hurt someone and still decide that you need out of the relationship. So I don't think there's anything inconsistent with that. So that was the last thing I wanted to say. So are there questions in the chat? I will try to take them. I see any, but here's one. Okay. Flora by the Sea. Sorry. If a juror knows that if a defendant testifies in the narrative, it signifies perjury, can the juror tell the rest of the jury? Well, in the first place, the juror shouldn't know that. You shouldn't have a juror who can see what's happening and say, aha, perjury coming. That would be a biased juror. And certainly that juror shouldn't tell anybody else. What that juror should do is to raise a hand and go to the judge and say, here's where I am. And should that happen, the judge would replace that juror with an alternate. But you can't have somebody serving on a jury who knows that the defendant is going to get on the stand and perjure himself, and therefore can discount everything that's said because he knows that the defendant is lying. It can't work. Can't work. Good question, but it can't work. Illuminating ink link. What is that? Illuminating link, I think. Since nobody was found in the trash, is it possible he kept her in the attic a couple of days, and that's why he removed the ceiling because of decomposition and later disposed her somewhere? I don't know. I don't know enough about what happens. There's going to be a smell, and to give you almost none of us can have experienced it firsthand unless they're law enforcement officers who are in this chat. But to give you a feeling about it, has anybody had a refrigerator go on the blitz, and maybe you're away from the weekend and you have meat in the refrigerator and you come back? You'll get a sense of what that smell is. And it's really potent and it's really heavy, and carving a little hole out of the floor wouldn't handle it. So it couldn't be that. I don't know whether, maybe there was enough blood that it could have softened the floor enough that the hole happened, particularly if Brian Walshe put something on there that was heavy that might have pushed it down. We just don't know. And we'll never know for sure because he's not going to say. But so something along that line may be true. Certainly something along that line is more accurate than my thinking somebody took a metal spear or something, punched a hole, I don't know, because there was nothing else to do on New Year's Day morning. But that was the best I could do. Why wasn't there GPS on the ankle monitor? I don't know. There just wasn't. What I think it was at a pretrial hearing. I don't know where I heard the testimony on this, but you can have GPS ankle monitors that, with the GPS in it, and you can have them without. And I don't know what the anklet does if there is no GPS in it. If you're not going to be able to follow somebody around, what does that anklet add? I don't know the answer to it. There probably is an answer, and it may be a good answer. It's just not an answer that I know. Melmac 685. Was Melmac that used to make dishes out of it and it wasn't a plastic? I'm probably wrong, but that's that's where my mind just went. Melmac 685. Have you seen anything yet for a future appeal? Thanks. No, I have not. The judge is protecting that record better than any judge I've ever seen. Now, that doesn't mean there won't be an appeal. If he's convicted, there will be an appeal. So he will point to things that he appeals on, but the chances, so far as what I've seen, that there is something on which he can win on appeal, I don't see any at all. At least not so far. Nothing. There's a mountain of evidence, and as long as there's enough in that record to show some engagement before the morning of January 1, and I think there is enough, I think the murder 1 conviction is solid. And at the worst, if he's convicted and it's overturned on appeal, the state can still go for murder 2. And the judge can, of course, by that time, the judge can still sentence, if he's convicted on murder 2, can sentence him, whatever that maximum is, to run consecutively to whatever the sentence, by that time it will have been imposed, whatever the sentence was that was imposed on the illegally disposing of a body. Okay. Any other questions here? I thought today was much more interesting. Certainly, the first day I was just overwhelmed by, and I'm usually somebody that when it gets for everybody else really boring, I enjoy it. I don't find it boring at all, but I had trouble on Monday. Questions. Why wasn't the nanny subpoenaed and the mother? I don't know. Those are tactical decisions that the prosecutor makes. And part of it is, does he think he's got a strong enough case without? Part of it is the witness going to bring some difficulty or allow the defense to make some hay out of it? The best example is who's the detective who's now been fired from the Karen Reed trial, and they did a part of his testimony, his interview, but they did it on audio. What's his name? Somebody put it in the chat. You all know who I'm talking about. The Commonwealth could have called him to testify, and he could have testified about what he knew, but in terms of the interview, Proctor, yes, I should remember it. Thank you. Ain't no hollow back girl. And so he could have done that. That evidence wasn't important enough. They could get in the same evidence from somebody else, and that's what they did. They had another law enforcement person on the stand, and then they played the tape. And it carried so much negative for the Commonwealth and so much potential for the defense that it wasn't worth calling. So that's the calculus that the prosecutor is making. I don't know how that calculus applied to the nanny. I can guess about the mother, but with the nanny, I don't know. They may have felt they had plenty or sufficient other information that they're also trying not to have the trial go 6 months, that they didn't need that witness. As to the mother, she's going to be a hostile witness. She was going to be very hard to get information out of. And when she says he didn't know that I hired a private detective, they may not have anything direct that they can confront her with. The inference that he had to know is something that they may be able to suggest to the jury anyway. If they put her on the stand and she says absolutely not, particularly if it's credible, it will lessen their ability to make that argument. It won't enhance it, it will lessen it. So, but again, I'm not in the head of the prosecutor, and you should know that, because the other day I was complaining that we were seeing these photos and I just couldn't imagine why. And now it looks like we're going to find out that they had a good reason for it. So, okay, plants and recreation. First, thank you for your explanation of lesser included. So helpful. Thank you very much. I appreciate that. I try. Do you know anything about this judge and her reputation? I have heard from other lawyers who practice in Massachusetts, including the lawyer who was on STS last night, that she has a really, really strong reputation in that area and probably in the state. And she didn't have to say that for me to know that, because you can tell how good she is. So if you can watch her and know she's that good, she obviously has a good reputation among the lawyers. And one thing she does that will make her loved by the lawyers is she's decisive. She doesn't take forever to decide something. I mean, I think most lawyers would rather have a judge make a decision that goes against them than have a judge that waffles and doesn't make a decision. In part because if you've got my mentality, it just drives you nuts. But in part, you can't prepare your case because you don't know. You don't know, will it be in? Won't it be in? Will part of it be in? How much of it will be in? It makes it impossible to get your case prepared. So a decisive answer, even if you don't like it, is generally a better answer. And I think her answers have been right on the law. And so I think she's doing a really, really great job. As I said yesterday, my only complaint is she's got dilettante hours. She's running a boutique. But I was told by people in the chat that those are the hours of many judges on that bench. And I will say what I should have said yesterday, and I will say now, the judges are not only doing trials, they're doing a whole lot of other things. She's probably got other trials that she's doing. There are going to be pretrial motions on those trials. She may have a sentencing hearing in a trial. She's got administrative work to do. All those things also have to be done. And particularly the other trials, you just can't say, I'm not doing anything on these other trials until this one is done, because that's not fair to the next defendant and the witnesses in that case. So although the hours, I must say, drive me nuts, she has a pretty good reason for why the hours are the way they are. And she's moving the trial with alacrity as she goes. So it isn't as though she's not doing 8 to 5, and she's also, fluttering around and not being decisive. And so we have a lot more time that's being taken up. In court, she makes use of every single minute, and she comes in prepared. She knows what information she wants. She'll direct which is again wonderful. She'll direct the lawyers. Don't tell me about this. This is the issue I'm worried about. So focus your argument here. It's just great. I really like her. Of all the judges I've seen watching YouTube trials, and those that I've seen when I practiced, and those that I've seen when I took students in to watch trials, she is the best. Okay, question from Nana of 07. Nana of 07. Okay, confused about the necklace. What was that about? That's another one that hasn't tied up completely. I believe, and if someone in the chat knows for sure, just correct me, believe that a necklace was found in the dumpster along with other things. I'm guessing that that's the necklace that they had Fausto identify in the photo, and that they're doing it to show that it was her necklace and she had it on the day that she died. I don't know why it's so significant. So there may well be more to it, and we don't know yet. But you're right. They are talking about the necklace, and it's like the hole in the ceiling. It isn't fully explained yet, and hopefully by the end of the trial we will know. There's also the business of the engagement ring, which, so far as I can tell in the pictures, is a pretty big diamond. And I don't know that that's surfaced. It certainly wasn't in the trash bag that they found. And the prosecutor today did ask the law enforcement officer who was testifying, "Do you see an engagement ring in the photo?" So he made a point of pointing to it. So I guess the last comment, now that I think about it, is uh, Brian Walshe, through his lawyer so far, is saying there really weren't money troubles, that they had all this investment property. Not clear to me how much of it was in his name, but they had investment property. They could borrow on the insurance policies. Uh, that's the case they're making. The counter to that, obviously, is his mother's paying the rent. The investment properties may be in her name. Not clear how much, if there were a divorce, he'd get. Massachusetts is the third worst state for men. That's what he found when he did his Google search. But in addition to that, it's curious to me, and this will never get before the jury. The jury does not know that the lawyers in this case have been appointed by the Commonwealth and are being paid by the Commonwealth. These are not private attorneys that he's paying out of his own pocket. These are private attorneys that go through, there's a system in a lot of states. You do the PD, the public defender's office, and then there are lawyers who qualify and volunteer to take on cases for the Commonwealth. They don't make what they would make if they were charging, a client on a private arrangement, but they make more. They make some money, and of course, in a big case, they get a lot of free publicity out of it. So, and they may well feel also, I don't want to suggest that they're just being, greedy. They may well feel an obligation to come in and help out for clients or for defendants who don't have the money to pay on their own. But it is curious to me that Brian Walshe, who says there's no money trouble and not a problem, can't pay for a lawyer on his own. And of course, as I say, that's never going to get in front of the jury, but it would certainly be on your wall, a fairly significant brick that his story that money was not a problem wasn't true. Okay, let me see if there are other questions. And if not, I will sign off. Oh, here's one. This is from at Parisian 44. And, nobody has explained to me. I asked earlier today why the numbers at the end of these, particularly the numbers that are in the thousands, whether there's so many names that you have to put a number that long, or you like doing it, or what, because I really am curious. Anyway, Parisian 44 or at Parisian 44, can they subpoena the private detective to confirm he worked for Brian Walshe's mother? The question, first of all, it's not clear to me yet that the fact that the mother paid for an investigator will even get into this trial at all. They're going to have to show some nexus that Brian Walshe knew that his mother hired the private investigator. They may be able to do it, but it may be far enough out that they don't want to be expending time and diverting the jury's attention to that. And unless that happens, the private investigator can't testify as to who was paying him, because there wouldn't be any reason for that. So my guess is that particular information is not going to come into the case. It's not that it wouldn't be relevant, but there's going to be an argument about did he know, did he not know? And it's kind of a diverting. The Commonwealth has a pretty clear road to the conviction and may well not want to introduce something that they don't need. Okay. Denben 8530. Why were the text messages between her lover and Anna, why didn't they go anywhere today? Why did the judge put a stop to it? No, I don't think the judge did. The prosecutor just didn't introduce it. Now, maybe he'll do it later. And the emails that they were arguing about are in evidence. So he's perfectly free, although he didn't ask any questions of the witness, to refer to those emails in closing and make an argument from the emails, because he's entitled in closing to not only talk about the evidence, but to talk about reasonable inferences from the evidence. Can't do it in opening. You're not supposed to argue in opening, but he's free to do it in closing. For those of you who watch the Adelson trials, or at least Donna's trial in particular, at the closing, and during the trial, the defense had been arguing that the prosecutor did not introduce all the Celebrite records of the calls among Charlie Adelson and Donna Adelson and Catherine Magbanua. They only picked a certain period of time. And the defense lawyer said they were entitled to have them all go in, and the judge said, no, then, there's a time frame, and after that, there's no relevance. Tell me why they're relevant. But you can argue in closing about it. So the defense did, and what Georgia Kappelman, the prosecutor, did in closing was to say, yeah, we selected some, but it wasn't that we were trying to hide anything from you. We just thought these were the most relevant, and we were mindful of your time. If you want to go look at the whole, there's a box of these records, feel free. You're the fact finder. So the defense was arguing an inference from the records that were introduced that the prosecutor was hiding something. It's in closing, you're entitled to argue the inferences. There was another place where, if you recall in that trial, the night of the shooting, there's a text message from Donna to Charlie outside your house, and then a text message from Charlie to Donna 10 minutes. And the defense argued that didn't mean she was outside the house because there were no phone records that showed it. She had turned the phone off. Prosecutor argued, you know what? You got outside your house in 10 minutes. We think outside your house means you're outside your house. That's an argument. That's pretty clear inference from that evidence, but that's the prosecutor arguing an inference from the evidence that's in the record, and they're entitled to do it. So to get back to where I was, the fact that those text messages that we haven't seen, or at least I haven't seen, are in the record means they will go to the jury, and that the prosecutor is entitled to argue an inference from them, and the inference is going to be that there was trouble in the marriage. So anything else, or what we're going to be done? Okay, here's Denbin 8530. I see it on the side, which is let me try some water. Excuse me. Okay. Denbin, guilty of the first degree, that means he will get off the murder charge. No, first degree murder is the highest murder charge. So if he's guilty of that, you couldn't be convicted to anything higher than first degree murder. There is what's called greater to lesser, and I think I did this yesterday. I'm going to use letters. And what this means is the top crime may be you have to prove 4 elements, A, B, C, D. And that's the most serious. That's the one that carries the highest penalty. Beneath that, there may be a crime that is A, B, C. Beneath that, there may be a crime that's A, B. If you're convicted of the crime that says A, B, C, D, you obviously also committed the A, B, C, and the A, B. You can't get to A, B, C, D if you didn't do the others. They're lesser included because there's only one act. So in a murder of Anna Walshe, there's only one victim. There's only one killing. It could have been done. Could have been an accident. It could have been manslaughter, heat of passion. I got so angry that I couldn't control myself. I hit her. I didn't intend for her to die. She died. Manslaughter. It could have been, I intended it. Murder 2. Murder 1, I premeditated and intended it. What changes is the mental state of the actor. The act that I managed to cause the death is there all the time. But you can only be convicted once for that. You can't be convicted twice for murdering somebody once. And the issue is how serious in this hierarchy is what you did. And murder 1 is the highest that you can go. If he's convicted of murder 1, that's the best that anybody can get out of this. You can't bring Anna Walshe back. Okay. Any other questions, or are we? I don't see any more. Rest my voice. Yeah, I don't usually have this problem, but the last couple of days I have. Okay. I don't see any other questions. So unless somebody puts a question up, we're going to be done for tonight. I said on the chat earlier today that I wanted to thank everybody who had watched the one video I've posted so far on the Wendy Adelson situation and whether her immunity means she can't be prosecuted. I have a lot of people who watch it. It was really gratifying to me, and I'm not above saying that that sort of thing pleases me. I should be more humble and modest and not say it out loud, but it does please me. Uh, if you haven't watched it and you have a question about derivative use immunity, then I think that video may help. But in any event, that video is out there, and probably on Saturday, we will release another video, and this one will be on Donna Adelson. I looked at Donna Adelson's case, and I think it's 3 videos on what evidence she may raise on appeal, so that if you're following that at all, those videos will give you a heads up on what her appellate brief may look like. And the first one is focused on her murder 1 charge and whether there's enough evidence to support the jury verdict on murder 1 in her case and what the consequences would be if not. But I'm not going to bury the lead. I think the murder 1 conviction is going to stand. But anyway, that's the video that's coming out in a couple of days. In that series, I also have another one on Wendy on what evidence would be admissible at her trial. A lot of us have talked about all the evidence that's out there, but I wanted to focus on not everything that's out there, but what in fact could get into evidence at her trial and how that evidence looks. And I won't bury the lead there either. I think her conviction would be much harder than the others, but I think it's a doable prosecution, and I think they should go ahead and do it. So that's coming up on my next video. And so I thank you all. I thank everybody who subscribed. If you haven't subscribed, I really would appreciate it if you would. I don't understand the algorithm, and I'm not sure I even want to look and try to understand the algorithm. Sherlock Holmes said, and he was wrong, but he said, your brain only has so much stuff you can keep in it. And so if you put something in, something else has to leave. And he did it to defend himself for not knowing that the earth revolved around the sun. Which is quite an extraordinary view of what you don't want to have in your head. So you've got room for something else. But the algorithm, I am told, it matters if there are likes. It matters if someone watches a program or watches a significant part. But what also matters is subscriptions, and subscriptions don't cost you anything, and they help my algorithm. So it's a good thing for me, and I don't think it really is much. I don't know, but it doesn't seem to me that it would be too hard for you if you like the content. If you don't, then obviously don't do it. And so I thank you, and I am going to say ciao a tutti, and particularly ciao to my proffers out there. It's been a pleasure getting to work with you, and I hope we have many more opportunities. So long.